Because it is beneficial for a person in nowadays to say, I'm black. But if you see obviously that person isn't necessarily black, on what basis will you make that judgment? And that the government has helped us. They say you go back to the race law that formed the basis of apartheid, the Population Registration Act. They say that is the basis how you classify people. That is what the department has told us on Friday, in writing. Now that is extremely serious. So it is a repealed act, but they say you base your decision on that. You do the test in terms of that act. That is the answer of the department.
For the 15 January 2026 deadline for employment equity baseline reporting, employers are scrambling to meet the new rules, while the National Employers Association of South Africa, NEASA, warns that parts of the system are simply unworkable. Under the new baseline submissions, companies must give the Department of Employment and Labour a snapshot of their current workforce, reporting on hiring, promotions and terminations, and align their equity plans with the preset sectoral targets that run until 2030. But NEASA says employers are being put in an impossible position, especially where staff refuse to self-categorize by race or disability, leaving companies legally obliged to classify workers themselves using historical or existing data. Let's hear a bit more about that then. Gerhard Papenfus is the CEO of the National Employers Association of South Africa. Good morning to you and thank you for your time. I saw the open letter that you wrote, quite extensive and covers a lot of your concerns. In essence, what about this looming deadline as far as the online submissions are concerned is a matter of concern for you?
Yes, good morning, sir. Well, there are numerous reasons why we won't be able to meet the targets set by government. And we need quite an extensive opportunity to elaborate on that. But one of the things that we raised is the issue of race. It is now expected of an employer to classify his employees. Now, that is impossible. There is no legislative imperative on which we can base that. How do you classify a person that, in terms of race, if a person says, I'm not going to classify myself, it is expected of an employer to do that. That's simply impossible. There is no basis for that. And the Department of Labour has surprisingly responded to our letter. We didn't think that they were going to respond. At least we thought that they were going to give proper thought to this, but they didn't. They respond, and they said we must base it on the 1950 Population Registration Act of 1950. They say that's the basis how you classify people. That's their response, the official response by the Department of Labour. Isn't that surprising?
Yeah. So say a bit more about that. What's the difficulty when they say use historical or existing data? Because I suppose this is a bit of a story that sometimes it feels like it needs to be explained a bit. So the requirement is that employees, workers should classify in terms of categories, including race and whether or not they have a disability, but they're not obliged. Where they refuse to do that, the responsibility then falls on the employer to do that. What's the difficulty with the historical or existing data, in the sense that isn't this data that the employers have been collecting anyway? The forms when you're getting employed for employment equity requirements, people tend to have those forms at hand.
Well, if a person reckons that judges that it is beneficial for him to classify himself as black, for instance, how can you differ from that person on that basis? On what basis? If that person doesn't look black to me, but I say, you're not black, you're something else, on what basis do I make that judgment? Because it is beneficial for a person in nowadays to say, I'm black. But if you see obviously that person isn't necessarily black, on what basis will you make that judgment? And that the government has helped us. They say you go back to the race law that formed the basis of apartheid, the Population Registration Act. They say that is the basis how you classify people. That is what the department has told us on Friday, in writing. Now that is extremely serious. So it is in a repealed act, but they say you base your decision on that. You do the test in terms of that act. That is the answer of the department. If a couple, an Indian guy marries a white woman and there's a child, what is that child? If that child is white, obviously, but he classifies himself as Indian, what do you do with that? Because they say I'm responsible as employer if I mislead the department. So we say that's not our job. There is no imperative, legislative imperative on which we base that decision. That is our dilemma. The state has entangled themselves in a mess here. They say you classify a person in terms of race. We say, how do you do that?
All right.
You expect me to do that. I cannot do that. But as I said, they've now given us the indication of how to do it. They say you base that decision on the 1950 Population Registration Act. That was the act on which apartheid was built.
All right.
That is the Department of Labor's response.
Okay, I've got to leave it there. We'll be sure to get other perspectives on that story. That's Gerhard Papenfus, who is the CEO of the National Employers Association of South Africa.